Good morning, good morning, good morning, friends, colleagues, and esteemed family professionals. It's absolutely wonderful to see so many of you in the session with us today. I really look forward to spending some time with you going through some of the most notable events in the world of family law in January 2024. Let me get my slides up and then we can get cracking. As mentioned on the slide, you are absolutely welcome to type comments, questions, queries, opinions in the chat bar, and we will try our absolute best to deal with those comments, queries, questions, etc. We've got a very interesting January behind us, and I look forward to going through two administrative developments and 17 unreported judgments, and that is excluding 3 further unreported judgments, which slid in right at the end of January on the 31st, which I'm going to be unpacking in my February roundup next month. So I look forward to going through this presentation with all of you. I really hope that you derive a lot of benefit from today's session and that we can all maximize our potential in working with families. So, folks, welcome to Family Law Roundup, January 2024. Before we get started, what is Think Legal? We believe in legal knowledge open to everyone. This initiative, which we started just after COVID or during COVID as a mechanism to stay sane, has really, to my mind, grown into something that I think the community can be very, very proud of. Our ethos revolves around this. We acknowledge that the delivery of legal services is for the most part a commercial venture, but we uphold the notion that legal knowledge is a public resource meant to be freely available to everyone. Adhering to our dedication to facilitate open dialogue and share legal knowledge among professionals, we organize a variety of activities, including the management of WhatsApp groups, hosting regular webinars, and arranging social events such as we are doing today. So for those of you who would like to join the communities, Nadia will be pasting the links to join our Facebook our WhatsApp groups. These are free to join in terms of family law, and then on the next slide I will show you commercial litigation and labor law. They are free to attend for industry professionals, and please do join the conversation if you are interested in being on the WhatsApp groups. Now, just a word to those lovely people who are supporting us and who help us to keep Think Legal, for the most part, free, obviously supported first and foremost by Vermeulen attorneys. And I'm very, very proud and pleased to say that today, literally today, marks the 10th birthday of Vermeulen attorneys, and it's been absolutely such a blessing to augment the practice with this Think Legal initiative, and then also by Lawbox practice management software by lawyers for lawyers. You can try Lawbox for free for 14 days. Go to lawbox.co.za and you can sign up for free. Right, folks, a last plug, and then we can get into it. On the 27th to the 29th of February, I'm running 3 evening classes, which I'm calling Divorce 101, and I took the time to have this NABFAM accredited through SAM. So those of you who would like to brush up on your CPD points, this 3-night session is a lovely opportunity to do so. Session 1, we delve into the basics of divorce, legal requirements, structure of divorce courts, and the powers of the courts. Session 2, we look at substantive issues, including various issues such as accruals, spousal maintenance, proprietary consequences, and then the very new, very old concept of Section 7.3 claims, which obviously came about due to the constitutional courts intervention, not interference, intervention is a better word, last year. So to celebrate our 10th birthday, if you use the promo code VLAW10 when booking via Quicket, you get 20% off. Standard tickets are 750 Rand and candidate attorneys get in for 500 Rand because we all know the trouble and strife of our poor candidate attorneys. Right, so as we get started, for those of you who would like to get hold of the course material for today's session, you are welcome to follow the link which Nadia will post and get hold of it. You do not need the course material to enjoy today's webinar, but it will certainly, in my view, enhance your experience, and it will also be a good aid memoir in your practice. What does it consist of? It consists of these slides, 17 pages of case law summaries in respect to the cases that we will be going through. It includes the new South Gauteng Consolidated or the Gauteng Consolidated Practice Manual, as well as the DOJ circular, which has been making quite a bit of waves recently. And then finally, last but not least, the case law bundle, which I have taken the time to painstakingly paginate, as you can see on the screen. I think that is about 270 pages. The case law notes look like this and tell you basically the citation, the court, an overview, what legal principles were discussed, what was the outcome, and one or two notable quotes. We can term this case law for lazies, I suppose. So, as I say, you're more than welcome to go to our Shopify store to have a look at these. They are not necessary. You are more than welcome to attend free of charge, and I will do my absolute best to take you through the cases. So I'm going to start off on an administrative note first before we go into the cases, which I really look forward to discussing with you. And essentially, I'm going to start off with the Consolidated Practice Directive of Court Operations in the Gauteng Division, which comes into effect at the end of this month. Folks, this is not yet in effect, but it is a good idea to start brushing up on it. I'm not going to delve into extensive detail in respect of it. Safe to say that all of the important aspects that we generally find in practice manuals are there regarding, for example, judicial case management and case lines, etc. Case lines obviously still being a feature in the Gauteng area and not yet in the rest of South Africa. Very interestingly, the compliance statements which have come in from Annexure 5, please take very, very careful note of that, legal practitioners, when you are looking for hearing dates. So, not much to say. We have a new Consolidated Practice Directive 1 of 2024 for court operations in the Gauteng Division, and please take note of it. For those of you who have the course resources, you are welcome to have a look at that PDF. Secondly, and this is something that's ruffled quite a lot of feathers, and I'm not going to go into too much detail for fear of getting shot, ostracized, and or otherwise, if I may say so. But this is Directive to Court Administration regarding mediation in domestic violence cases. Essentially, if we look at paragraph 3 of the letter, the department considers the use of mediation services in domestic violence matters as a malpractice, as the Act does not provide for such services. Now, this has ruffled quite a lot of feathers countrywide. There has been a lot of discussion regarding this. I know there has been quite a few training sessions on the desirability of mediation in domestic violence matters. There has also been some radio coverage on the aspect, etc. For now, this is a policy consideration from DOJ. I know it will have fairly far-reaching implications. We know, as family professionals, that domestic violence is a very nuanced thing. Friends and colleagues, obviously, it is not something where a one-size-fits-all is appropriate. This is something where we are seeing a lot of conversation, and obviously conversation is still at the end of the day a good thing regarding where the line needs to be drawn? And I think the answer to this question, the answer which I don't pretend to have, but the answer will come eventually in the form of distinguishing between mediating the domestic violence in and of itself, or mediating ancillary issues regarding and or related to domestic violence, as well as a consideration that, folks, domestic violence has, even in the face of the act itself, a very, very broad definition and various acts that can constitute domestic violence, with obvious differing levels of extremeness, if one can use that word. So this notice obviously has ruffled a few feathers. I would love to see some more discussion regarding this. Obviously, yesterday there has already been, and the day before, quite robust conversations on the platforms with which Nadia and I are involved, and it is great to see this discussion taking place. My appeal to everybody involved: let's keep it friendly, let's keep it cordial, and let's try and collaboratively discuss this issue to the best interests of families in crisis, who are the ones at the end of the day who we are called to serve. So, those are our two brief administrative updates. Be aware of this directive from DOJ regarding domestic violence, and further the Consolidated Practice Directive 1 of 2024. And on that note, I'm going to jump into the meat of today's discussion, which I really look forward to chatting with you about. There have been quite a few very interesting judgments that have come out in January, some which have got a lot of people talking, and some which have flown over or under the radar, and I think should have perhaps received a little bit more airtime in our family law circles. The first one, folks, I would like to talk about comes all the way from the Johannesburg High Court, and this is EVG versus AJJV. For those of you who are following along in our bundle, you can find it on page 1 to 22 of the paginated bundle, and on the case law notes, you will find it on page 1. Now, I've decided to focus quite a bit on this judgment itself, because it is a very, very interesting judgment. Essentially, what had happened is the applicant approached the court on Rule 43, seeking interim relief for maintenance and a contribution to costs. The respondent instituted a counter Rule 43 application and sought orders regarding exercise of parental responsibilities and rights. They also sought the appointment of a parenting coordinator. So some major issues were involved here, including maintenance payments, residency, contact with the children, appointment of the PC, if one has consideration of the order, even psychiatric evaluation of one of the parties. And essentially, the court, which was acting in this matter per beside note AJ, had a very, very interesting time balancing the interests of the parties in this matter. And what I'd like to show you, and I'll go through the outcome and some of the legal principles, but I think the best really is to just go through very briefly what was discussed. So we had a look at parental responsibilities and rights. We had a look at primary residence. We looked at contact and visitation rights, as we speak of colloquially, appointment of a parenting coordinator, and then a psychiatric evaluation, which was ordered on one of the parties. So what was the outcome? There was an order made for interim maintenance for the applicant and the minor children. There was specific contact set in place, and there was an order regarding the appointment of a PC, as well as a psychiatric evaluation of one of the parties, and also co-parenting coaching for both of the parties, as well as, last but not least, and very often most bitter, the dreaded contribution towards the applicant's legal costs. Now, I quite like the notable quotes that we find in this judgment, and it's for this reason that I decided to focus on it. I really appreciate what the judge said to the parties in paragraph 58, and I think it's a cautionary tale to all legal practitioners working with Rule 43 applications, where the court said that both parties claimed costs against one another. Both parties, however, approached the court with unrealistic expectations. Accordingly, I decline to mulct any of the parties in costs and will grant ordinary costs, the ordinary costs order in applications of this nature, as we know that is generally costs in the cause. My favorite quote from the judgment, and hats off to the judge in trying to facilitate this kind of via media, is the court said, accordingly, I'm of the view that the contact that I intend to order will provide a via media between the parents' expectations and what is ultimately in the children's best interests. For the above reasons, I also intend to grant an order for the appointment of a PC in an attempt to alleviate the acrimony between the parties and to minimize consequential trauma for the minor children. So essentially, folks, both parties received a partial measure of success, and obviously also the reason why the court decided not to mulct either of the parties with costs. Now, very interestingly, if one looks at the first order that the court made, it made almost a declaration that the parties remain co-holders of full parental responsibilities and rights, including guardianship. Now, very interestingly, and if one wants to nitpick, Rule 43, if one looks at Rule 43 sub A, makes provision for that the court or the rule shall apply in respect of maintenance pendente lite contribution towards cost, interim care and interim contact, guardianship notably absent. However, I think the judge can be forgiven for this insofar as no real declaration was made of any party's rights in respect of guardianship. The order in this judgment, folks, and this is one of the ones I really think is a must read in seeing the balancing act that judges do when dealing with these matters. The order in and of itself spans nearly 5 pages of various safeguards put in place by the court in respect of, inter alia, appointing a parenting coordinator to be appointed by FAMSA or the Gauteng Family Law Forum. It made provision for a psychiatric evaluation. It made provision for a further report by the social worker who was involved in this matter, Ms. Janet Herman. And then it made a very, very substantial number of provisions regarding maintenance and contributions to cost. In my view, EVG versus AJJV, all the way from the Johannesburg High Court under the pen of acting Judge Besaidenout, I think is one of those judgments which flew under the radar, which actually should not have flown under the radar. Very interesting and well worth a read. Bundle page 1 to 22. The second judgment, folks, can be found on bundle page 23 to 30 of our resources bundle. And if you want to follow along on our little summary page, you can find JG versus AN. Hopefully you find it quicker than I do. You can find it on page 16. And this is something which one very rarely sees in high court matters. And this is a matter revolving domestic violence or involving domestic violence. And essentially, what had happened in this matter was the appellant and the respondent were siblings. The appellant, a 59-year-old male, the respondent, a 56-year-old female. The respondent, who was the applicant in the domestic violence interdict. This was an appeal matter, as you can see from the case number A3132, the little A signifying an appeal. The respondent in the High Court, applicant in the Magistrates Court, alleged threats of violence and intimidation, including threats to her life. There was historical allegations of all sorts of sexual abuse and spying, etc. And what this matter really revolved around at its nub is, what is the definition of a domestic relationship under the Act? In other words, does the Domestic Violence Act apply, or must the applicant seek some form of different redress? And two notable quotes from this judgment, folks, is paragraph 17. The judge says, and this was under the pen, if I can just get my right page over here, this was Mudal J writing the judgment, Nell AJ concurring, and essentially the court says the provisions of the very legal instrument which are designed to protect those vulnerable sectors of society from domestic violence are often abused as a tool of harassment and to reinforce patriarchal domination. Now, very interesting, this quote. I don't think it goes to the heart of the ratio of what the court decided, but it really is a very interesting summary of the reality that one sees. We know that domestic violence is very often used as an interrorem tactic for litigants to get a heel in against one another. So interesting that the court made this specific statement. Then finally, a notable quote: principal objective of granting an interdict, family or domestic violence, as the Concord pointed out, is not to solve domestic problems or impose punishments, but to provide a breathing space to enable solutions to be found, not to punish past misdeeds, but to prevent future misconduct. At its most optimistic, it seeks preventive rather than retributive justice undertaken with a view ultimately to promoting restorative justice. And that, if one has consideration to the footnote in the judgment itself, that is on page 29 of the paginated bundle. Dion, thank you for that. This judgment specifically refers to Daffy versus Daffy as well. It is one of the ones referred to. Obviously, the court also referred to Plaskon Evans, but this paragraph 21, which I'm just going to put here I'm just going to park it there without comment, considering the big discourse regarding mediation in domestic violence. This citation is from State versus Beloy, Minister of Justice, and another intervening all the way back from 2002 to SA 425 Constitutional Court, paragraph 17. And I'll pop it up on your screens for those who would like to go and have a look at State versus Beloy. And the quote that we can find in paragraph 21 of the bundle comes from the Concord itself, regarding that domestic violence is not there to be retributive in its, or domestic violence interdicts, as it were, is not there to be retributive, but to provide breathing space to enable solutions to be found. I will just leave that there without any further comment. So that is our judgment of JG versus AN, Johannesburg High Court, where the court really looked at the scope and ambit of a domestic relationship, the approach taken in Daffy versus Daffy, Plaskon Evans, and State versus Beloy. Essentially, what happened here, the appeal was dismissed. And paragraph 22, the judge states, for these reasons, the magistrate correctly issued the final protection order. The appeal to this court must therefore fail, and there is no reason for the costs not to follow the event. So the domestic violence interdict remaining in place after the appeal to the South Gauteng High Court. Now, here is a very interesting matter in respect of in respect of customary marriages, not domestic violence. I think we've all got domestic violence on the brain at the moment. For those following along on our notes, you can find this judgment from page 31 of your paginated bundle to page 38. Now, this is a fairly simple ratio in respect of this decision, but I think it is necessary for us to have a look at it for completeness sake. I'm not going to spend too much time on the matter, and for those following along on our summary notes, you can find the full summary on the very last page, or the second last page of the bundle, page 17. So, essentially, what happened here? The applicant sought recognition of a customary marriage to the deceased and claimed a share of his estate. The respondents contested denying the existence of a customary marriage, and the key legal contention revolved around whether a customary marriage is valid if there is a pre-existing civil marriage. And of course, my dear colleagues, we know that this is not the case. Two notable quotes from the judgment. The applicant has failed to comply with Section 3.1 of the Act in that she failed to convince the court that lobola took place between the family and the deceased's family. The only assumption is that is common cause is that there was cohabitation between the deceased and the applicant. However, I will only concentrate on the issue of whether there was a valid customary marriage or not between applicant and the deceased. If so, it could not coexist with a civil marriage between the deceased and the deceased's civil wife, Mrs. A.B. Zuma. Then paragraph 31, the court goes on to say that it's my view that even if there was evidence of compliance with Section 3.1, which the court says already there wasn't, such lobola would be unlawful or invalid due to the existence of the civil marriage as mentioned in paragraph 14 and 22 above. So this judgment essentially telling us what we know already all the way from the KZN High Court in Durban, that if there is a pre-existing civil marriage, there cannot be another customary marriage entered into. Right, everyone's still with me. I see we've got quite a few of us still busy in the room, so I hope that you're all scribbling furiously and sipping your coffee. We've got quite a few more still to go. Next up, forfeiture of patrimonial benefits, MFB versus JB, all the way from Limpopo. And we're seeing, folks, quite a few interesting forfeiture of patrimonial benefits judgments coming out. There seem to be, for a good almost half a decade, a lull in forfeiture of patrimonial benefits matters. And I think in today's summary, we have already two that we're going to deal with, and there's another one coming up for the February roundup. So we're seeing a lot of judgments based on forfeiture. And considering we know in terms of Section 9.1, the court looks at the duration of the marriage, circumstances which gave rise to the breakdown thereof, as well as any misconduct. The idea of misconduct seemed to have fallen out of vogue for some time, but it seems that it is back and alive and well and subject to litigation. So, MFB versus JB, we look at forfeiture of patrimonial benefits, those following along bundle page 39 to 49, and on your summary sheets, you can find it on page 15. For those of you who are interested, Nadia will repaste the Shopify link if you would like to pick up the course materials, including my full notes that I did to prepare today's session. That link will follow shortly. So, what happened in MFB versus JB? The plaintiff sued for divorce, defendant counterclaimed also for divorce, and seeking a full forfeiture of patrimonial benefits, which included property and pension interests. The central dispute was the division of the joint estate. Plaintiff alleged physical abuse and financial control. The defendant alleged extramarital affairs. What essentially happened here? The forfeiture claim was not granted. The court said that there was not sufficient grounds. Division of the joint estate was ordered, and the GEPF, which was the pension fund involved, was ordered to pay out 50% in respect of Section 7.7 and 7.8 of the Divorce Act. Two notable quotes, essentially one notable quote. In my view, the defendant, the one seeking the forfeiture, did not manage to prove that the plaintiff was the cause that gave rise to the breakdown of the marriage. In addition, in my view, the defendant did not prove any substantial misconduct on the part of the plaintiff. In the result, the defendant's claim for forfeiture must fail. The court, obviously referring back to the most seminal judgments, it looks at Section 9.1 of the Divorce Act. The court looked at Section 7.7 and 7.8 of the Divorce Act. Interesting to read. And obviously going back all the way to Buerta versus Buerta 2006, which was an SCA matter, and our locus classicus Vaker versus Vaker 1993, which is discussed in quite a lot of detail by the court. So, division of the joint estate, the forfeiture claim fails, and this under the hand of M. Nodia Woodendal J. from the Limpopo Division of the High Court in Polokwane. Right, next up, we are going into quite a traumatic judgment, folks. It is worthwhile just to take a deep breath before we go into this one. And this is a very tragic matter of Welgemoot and another versus Potgieter and others, all the way from Pretoria. Now, essentially what the court is dealing with in this matter is all the way from parental responsibilities and rights up to and including the roles and functions of a curatrix ad litem for minor children. For those of you following along, this judgment on the summary is on page 2, and in the case law bundle, you will find it from page 50 to 65. The facts of this matter, the application was brought by the curatrix ad litem pursuant to the respondent's obstruction and frustration of processes. In respect to these children, their parents had passed away. The maternal grandparents were appointed as the guardians, and there was a lot of fighting between the extended family of these children. Curatrix ad litem was appointed to investigate and recommend on the children's best interest. There had been a long history of litigation, and the court really emphasized the necessity for therapy, etc. A very, very interesting judgment to read in respect of how the court reasoned on the role of the curatrix ad litem, the responsibilities of the parties. And I've deliberately put our quotes on a different page because I think this judgment is replete with very, very powerful quotes that I think should be a bit of a reminder and a wake-up call to all of us who deal with families. And from paragraph 42 of the judgment, which you can find on page 60 of the paginated bundle, it's clear that there will be no winners should the parties continue on this trend, and that the ultimate losers will be the minor children. It is clear that all parties need professional guidance through this myriad with the ultimate aim to act in the interests of the minor children. Then paragraph 40, very sad, grown-ups lose their objectivity and use the children as clubs to beat the other. And ultimately, the children suffer the most trauma in the process. Paragraph 38, very important, court considering what we've termed colloquially the voice of the child. I'm well aware of the provisions of the Act regarding hearing the minor child, particularly when taking into account the age of the minor. I'm aware of the provisions of Section 10 of the Act to allow the children to participate, but the view of the child is only a factor to consider with all other relevant aspects as set out in Section 23 of the Act. Although a court should listen to what the minor children's views are, their views may not be in their best interests. Their views are not final and overriding the discretion of the court. The court reminding us not to throw out the baby with the bathwater when considering the views and wishes of minor children. Then finally, in respect of the curatrix, and I'm just going to take my picture off there so you can see the quote nicely. A curatrix appointed by the court has a particular function, is not a puppet for a particular party. The curatrix is there to investigate and report to court on the best interests of the minor children. And if during the process some of the party's toes are trampled upon, that party must endure it. The court will only intervene and remove a curatrix on grounds of misconduct, incompetence, or similar reasons. So essentially, the court telling the parties to stop their nonsense and play nice. That is Welgemoot and Another versus Potgieter and Others, and that can be found from bundle pages 50 to 65. Well worth a read regarding the need for ADR and open discussion when it comes to children, the roles of curatrix ad litem, and then obviously, as can be seen in paragraph 38, the voice of the child. Now we go into the realms of maintenance execution against a pension fund. That can be found bundle page 66 to 80, MO versus Oro and Another. And that comes all the way from the Western Cape High Court under the pen of Nziweni J. It is an urgent application, and that is for execution against a pension fund. This is one that deals with maintenance, as I understand it, for our numerous maintenance buffs that are in the room today. MO versus RO and Another, and that summary can be found on page 4 of the summary bundle. So what happened here? Married couple, applicant and first respondent, 3 minor children, divorce proceedings. There was a Rule 43 order granted for maintenance. The respondent defaulted. Contempt application led to a mutual agreement for the respondent to clear arrears, which the respondent failed to comply with. The already had last chance saloon. The applicant filed an application under Section 26 for attachment of respondent's pension interests to satisfy the arrears. The outcome was that the court ordered the attachment of the respondent's pension benefits to satisfy arrear maintenance, and ordered that in the case of future non-compliance, the applicant could notify the pension fund for necessary actions, and the respondent was ordered to pay the costs of the application. Notable quotes: esteemed colleagues, the applicant and the children have a right to do everything to make sure they receive what they are rightly due, and obviously rightly due in this instance because there was a court order granted, and court orders, unless and until set aside by an order of a competent court, must be obeyed. Section 26 is in no way meant to be onerous or to cause hardship for the person who is supposed to pay for maintenance. It serves inter alia to enforce an obligation that should have been fulfilled already. If memory serves, the submission was made on behalf of the respondent that the order sought would cause hardship to them. High shame. Then paragraph 31, from the myriad of cases, it is clear that a recalcitrant defaulter is someone who callously, persistently, and willfully fails to pay his maintenance obligation. MO versus RO, once again showing that if there is a court order for maintenance, you better comply, lest you face the wrath of Section 26. Right, here we go to the one that caused quite a lot of discussion and queries and comments and opinions across the board. And this is all the way from Pretoria, BMGS versus MBS and Others. This is a contempt of court matter. You can find it, bundle page 81 to 80 or 81 to 99. This was penned under the hand of Pashlane J, if memory serves. Let me just make 100% sure that I'm not helping you with incorrect. That's correct. It was Pshlane J, and you can find it on your case law notes on page 5. A lot of discussion in the media on this particular topic, and essentially why it had made such a splash in legal circles and in the media is because the mother in this instance was sentenced and committed to prison for 12 months direct imprisonment for contempt of court, a move which many commentators are calling a little bit heavy-handed. So what I would like to do is just briefly focus on what happened in this matter, what was the ratio of the court, and what does this mean for us going forward. So the applicant sought to enforce compliance with 2 earlier court orders. There was the Foster order and the Mosopa order. If memory serves, the Foster order was a Rule 43 order where there was to be contact to be exercised between the applicant and the minor child. The respondent, MBS, did not comply with that order, and if my memory serves, the Mosopa order was then granted, which committed the respondent to prison for, I believe it was 3 months for contempt of court. So this was the 3rd time that the applicant had to approach the court. The Rule 43 order was granted in 2021, of 4th of August 2021. That was the Foster order. You can see that on page 82. And then the first contempt of court order, the Mosopa order, was granted on 27 June 2022, just a year or so, or just under a year after the Rule 43 order. Then, unfortunately, in December of last year, the applicant had to approach the court for another contempt of court application due to no contact. What were the principles that the court looked at? So obviously the court took a very hard stance regarding non-compliance with court orders. It affects the rule of law and judicial authority. It had a look at what is the best interest of the child standard, which obviously, as we know, is paramount in family law matters as mandated by the Children's Act and the Constitution. It looked at parental responsibilities and rights under Section 18(2)(b) of the Children's Act. And the court made a big emphasis on court orders must be obeyed unless set aside by a competent court. And we'll look at that a little bit later. What was the outcome of this matter? And for those of you following along, I would like to direct you to page 98 and 99 of your case law bundle, where the court order appears. And essentially, the respondent was found guilty of contempt of court and committed to direct imprisonment for 12 months. And then prayer 5, which is one of the, or the order 5, simply says the applicant is granted immediate access to the minor child, and the first respondent is ordered to deliver the minor child to the applicant by no later than 5 o'clock on 5th of January. Now, we don't know whether this has happened. Is there an appeal? Is there a rescission? This was granted without the respondent being present in court, but the court was satisfied that there was sufficient notice to the respondent. In formulating its order, the court had a lot of words to say with regards to Section 7.1, and if my memory serves, I think it's 7.1e. And essentially, what the court focused on was the 7.1f. My apologies, folks, and that's at paragraph 19. The Children's Act provides in Section 7.1f that in determining the best interests of the child, the court must be guided by the child's need, in quotes, to maintain a connection with his or her family. In contrast, the need for the minor child to maintain a connection with his father is of paramount importance. What we don't see, unfortunately, if I may weigh in on this judgment, is a conspectus over the remainder of Section 7. And I think what one must consider, and in critical evaluation of this judgment, is first off the holistic view of the best interests of the child standard. One can consider the effect that this order would have on the child. Since 2021, at least that we know of, the child was primarily resident seemingly with the mother. What will the effect be of now incarcerating the mom? Secondly, what will the dynamic be going forward? However, one must, in the interests of understanding the court's rationale, understand that mom had already 2 bites at the cherry to comply. First off, where she should have complied was with the Rule 43 order. As we know, a court order that has been duly granted by a competent court must be obeyed. She decided not to do so. On the first round, when she was sentenced to contempt of court, I believe it was for 3 months, she did not report to serve the sentence, and the court then decided to take a very hard line in terms of Section 35 of the Children's Act, which gives certain powers to the court to jail someone for up to 1 year. And paragraph 42 and 33, notable quotes in this judgment. With that being said, it's imperative that the respondent understands that not only is she in violation of the court orders, but she has through her actions triggered a gross violation of the provisions of the Children's Act and the Constitution, which is the supreme law of this country. Her behavior continues to disrespect or defies the court's authority, dignity, and orders. And then a cautionary tale to legal practitioners from the judge. One of the important lessons which every legal practitioner should carry with pride is to adhere to the rules of court and properly advise clients. Every legal practitioner has an obligation to provide competent legal advice to their clients. It is a basic rule of law that court orders remain operative, valid, and enforceable until reviewed or set aside by a court of competent jurisdiction. And until that is done, the court order must be obeyed, even if it is wrong. So, folks, chatting along in the comments section, please let me know what your thoughts are on this judgment. Do you agree with my views on the judgment and my summary of the judgment? To those who have already treated themselves to the case law summaries, I would love to hear your feedback as well regarding what I've contained in those summaries. Is it useful to you? Is there something else you would like to see, guys, in LinkedIn land, YouTube land, Facebook land, and those watching on StreamYard? It's getting mighty lonely here. I would love to see some more comments coming in. Right, Z versus Z, folks. As we said, forfeiture is back, and it is back with a vengeance, as we can see in Z versus Z. Those following along, page 100 to 111. This comes from the Johannesburg High Court under the pen of Adams J, and the judgment delivered on 10th of January. Those of you who would like to follow along on the case notes, you can find Z versus Z on page 6 of the notes, page 100 to 111 of the paginated bundle, and obviously not to be confused with Z versus Z from the Supreme Court of Appeal, which was granted a few years back. Loving the feedback coming in, guys. Thank you so much. I really, really do appreciate it. So let's talk about Z versus Z. In this case, a partial forfeiture order was issued. The husband forfeited his wife's entitlement to or forfeited his entitlement to his wife's substantial pension interests, but he remained he retained the 2 immovable properties, which essentially the forfeiture. The court did a little bit of arithmetic, which you'll see in paragraph 19 of the judgment, of what was forfeited. So the wife initiated divorce. The marriage was solemnized in 1983, folks. It was a 27-year marriage. Now, for those of you who can do the mental arithmetic, 27 from 1983 does not take us to 2024. And essentially, what the court had taken into account is that the parties did not really live together as husband and wife from 2010 onwards. So the wife sought forfeiture of the husband's share in her pension interest, citing substantial misconduct and minimal contribution, and there was a partial forfeiture. So the court looked at the court couldn't really look at short duration. It was not a marriage of short duration. We're sitting with 27 years up to 2010, and then an additional 14 years thereafter. This is, for all intents and purposes, a very long marriage. Now, whether the parties were living together or not, the joint estate, by virtue of the provisions of the Matrimonial Property Act, still existed and still needed to be divided. And that's where the Section 9(1) claim came in. And what was the court's reasoning? That you can find in paragraph 19 of the judgment by Adams J., which is on page 108 of our paginated bundle. For the reasons mentioned here and before, and in particular the substantial misconduct on the part of the defendant during the subsistence of the marriage and his lack of any meaningful contribution, I am of the view that such a benefit receivable by the defendant would be undue. And the court concluded that there would be an undue benefit if there was no forfeiture to be granted. Now, very interesting, folks. If one goes back to our seminal cases, I believe Botha versus Botha, Vaker versus Vaker, etc., the court has a twofold inquiry with a Section 9(1) claim. The question to be answered is, absent an order for forfeiture, will there be undue benefit? And then the court has to look at the three factors: duration, misconduct, circumstances, to establish whether the benefit is undue. Very interesting, and something which I was very fortunate to be involved in a matter a number of years back. We looked at the idea of contribution to the joint estate and financial misconduct, not contributing, being profligate in one's ways, etc., etc. Does this constitute misconduct or not? And it's interesting to see Adams J in Z versus Z really does saying that contribution to the joint estate in these instances does play a role. It would be nice if the Act had spelled this out, maybe one day. It will. For now, it does not. But the way that the court interprets it certainly looks at the idea of meaningful contribution to the joint estate. Right. That is Z versus Z. Bundle page 100 to 111. Then we go on to another customary marriage matter, all the way from Pretoria, and that is the matter of Kashane versus Minister of Home Affairs and others. You can find it bundle page 112 to 126 in your case law notes. For those of you who are following along, you can find it at page 7 of the notes. And if I may, just as a side, so this is the first time in quite a while I'm presenting with two screens, and it's just making it so much easier. So I am absolutely delighted as I sit here today to be able to jump between the two screens. Not that that is relevant to any of you, but I hope it does give you a bit of a better experience of the webinar. So what do we deal with here, folks? A customary marriage, posthumous registration thereof. The first respondent, obviously Minister of Home Affairs, so we are dealing here with an administrative issue. And the question is whether the death of a spouse before registration of a customary marriage invalidates a customary marriage under the Recognition of Customary Marriages Act. And in short, the court was very, very curt in its judgment, not a very long judgment, very concise judgment. The court essentially said that the death of a spouse to a customary marriage before registration is not an impediment to registration. At paragraph 43, the court says, in conclusion, based on the evidence provided, it's clear that the marriage between the applicant and Mr. Mutswari was validly concluded in terms of customary law. The subsequent death of the husband should not be a bar to the registration of the marriage. Now, folks, why is this registration of the marriage important? Well, it's important in terms of intestate succession. If the marriage was not registered, then obviously the customary marriage wife would have a very difficult time inheriting from the estate. Our quote, paragraph 43 of the judgment, can be found on page 125 for those who are keeping tabs. Straight, clear-cut, simple judgment from Kinwana AJ, sitting at the High Court in Pretoria. And essentially what happened here, what was the outcome? DOH, Department of Home Affairs, was directed to register the customary marriage and issue a marriage certificate within 30 days. Good outcome for the applicant, and I don't think there could have been any other outcome. We're making some fairly good time, folks, but still quite a lot for us to go through before I release all of you back into the wild. 55 minutes in, everyone seems to still be going strong. Right, now another one from Pretoria. Interesting matter with some interesting dicta from the court. Rule 43.6 for a top-up on contribution to costs. This is ZG versus JGCG. And that is all the way from Pretoria. Those following along, you can find it page 127 to 162. It is a very long judgment. It's impossible for me to really put everything here for you. I think I've got the highlights. Let me know in the comments whether you agree with me or not. But for those following along, the summary is on page 8 of the summaries table. I invite those of you who don't have it yet to also go and pick those up as an aid memoir within your practice. So what happened here? A Rule 43 order was granted for a contribution to costs. Let me get my Rule 43 open here in front of me. And it was shortly before trial, the applicant approached the court asking to get a further contribution towards costs. The court looked at the principles of financial disclosure. It looked at what constitutes good grounds to get a further contribution to costs, and essentially it dismissed the applicant's claim for a further contribution to costs. Now, very notable quotes, folks, from this judgment, and I think this is one of the quotes that we can't ignore. We know that there has been a lot of movement in the realm of Rule 43, especially in respect of contribution to costs, and one can look at specifically the judgment by Victor J regarding the constitutional lens that we have to consider these types of matters through. But in this judgment, the Pretoria High Court, sitting under the pen of Moramuagai AJ, tells us not to throw out the baby with the bathwater. And paragraph 97 of the judgment, and I'll scroll down all the way there, the court says the following: while there is a tendency, and for good reason, to generalize the vulnerability experienced by women during divorce proceedings, there are exceptions to this norm, which courts are also constitutionally obliged not to turn a blind eye to. In my view, the applicant in this case fits into that exception and ought not to be considered in terms of the general vulnerability described above. The applicant is a businesswoman who is a sole member of a trading closed corporation and a sole director of a trading company. Both these businesses generate money from which the applicant derives income that can be used to pay for her legal fees. The applicant failed to fully and frankly disclose her income to the court to demonstrate her need for further contribution. So unfortunately for the applicant in this matter, she was not successful in getting a further contribution to costs shortly before trial. One of the reasons evinced by the court was that she was not financially vulnerable, and the court was not very happy with her financial disclosure. The court also made an interesting finding regarding 43.6, wanting the applicant to show a change of circumstances for a further contribution to cost. The wording of Rule 43.6, the court may, on the same procedure, vary its decision in the event of a material change occurring in the circumstance of either party or a child, comma, or, my emphasis, or in capital letters, the contribution towards costs proving inadequate. Some criticism I have heard regarding this judgment, the question of whether it is necessary for a party seeking an additional contribution to prove a change in circumstances. Very interesting quote, paragraph 98, the judge says, both parties are represented by reputable firms of attorneys with competent lawyers, as well as senior counsel on both sides with exceptional family law experience and expertise. Both teams of lawyers are ready to represent the party in all these proceedings, including the divorce trial. There's no indication that any of these lawyers would withdraw their services in this case. So the court essentially saying, let's forge ahead. That is ZG versus JGCG, bundle page 127 to 162, and that is on contribution to costs. Right, let's go down to the Pretoria High Court again, contempt of court. This deals with financial contempt of court. You can find it from page 163 to 175, also under the pen of Morimukhai AJ. And essentially, this comes down to whether a party is in fact in contempt of court for short payments in respect of certain payments or not. And a very interesting ratio by the court in this instance in respect of whether the respondent was in contempt of court. Summary on our summary tables, page 9, for those following along. So essentially, the parties had to run to court for a shortfall of 38,000 Rand in respect of municipal electricity bills. The cynics out there could question the wisdom of running to the High Court over 38,000 Rand. However, I will not focus on that. Essentially, if you are litigating in the High Court and you have to go ahead with contempt of court, you have to go in the High Court regardless of your quantum. Obviously, electricity bills is a recurring thing, so one can assume that the applicant wanted to avoid this racking up over the long term. So the court was required to assess whether the respondent was in contempt of court, and if so, what would the appropriate sentence be? And essentially, the court had a look at paragraph 31, I think is the real lever point, if one could, or the fulcrum of this judgment. The allegation is not that the respondent stopped making payments, but that the payment has been inconsistent and not made in full. The applicant wants the court to disregard all the other payments and focus solely on the municipal bill. Unfortunately, this was not the only financial obligation placed on the respondent's shoulders. To establish whether the respondent willfully and in bad faith failed to carry out the court order, he must be judged holistically regarding his commitment to the payment of all the items included in the order. So the court said essentially, because the respondent paid some of the other aspects, and there was some discussion in the judgment regarding the difficult financial position the respondent was in, that he was not under contempt of court. And I see, Laurie, you're mentioning paragraph 40. I thought I would throw it in there for the mediators out there. I think this is quite a nice quote, and there have been actually quite a few nice quotes, I think, from the courts being sympathetic to mediation, which I think is some great news for the industry at the moment. The judges are cottoning on. I am of the view that every divorce can be settled. Here, folks. The question obviously is only when and under what circumstances. It is only when parties are extremely positional and do not pause to consider the reasonable interests of the other party that divorces become difficult to settle, particularly when emotions are still high. I'm also of the view that there is no need to burden any party with the costs of the application. And we know, folks, as family professionals, cooler heads can always and should always prevail. There is no need for, in most instances, for overly aggressive, acrimonious, positional litigation. Most problems can be resolved. Even when there is a decision that needs to be made by a court, it can be done in a civilized manner. And this, once again, a call to everyone to be collegial and let's play nice. Everybody love everybody, I suppose. TR versus SM. Relocation, page 176 to 193. And you can find the update or the summary of it on page 10 of your notes. And essentially what happened here, mom wanted to relocate with a 12-year-old daughter to Kenya for an executive position, and the respondent opposed the relocation. Mom has been primary caregiver. Dad had limited involvement as found by the court in the child's life and financial support. The court granted mom's application to relocate, dispensing with the father's consent, and preserved, obviously, some of his PRR in terms of contact, etc. A very interesting cautionary tale for obstructive dads when it comes to, or obstructive parents or non-resident parents, let's use that term, when it comes to relocation. That can be found on paragraph 48 or 45, apologies, of the judgment. You can find it on page 190 of your bundle. The respondent must take responsibility for the limited time he spent with his child. Payment of maintenance does not secure his role in her life. More is required. He must keep contact with her and share his time with her to nurture a meaningful life. In any event, he has not paid any significant amounts to date. I noted that only after the application was launched and the litigation progressed, he paid over 16,000 Rand towards her annual school fees of 150,000 per annum, less than half the annual cost. If he is unable to meet her financial needs, which is a reality in every child's life, and mother has managed naturally, it is in her best interest to be with her mother and their family in Kenya so that her needs can be met. It is noteworthy that he was able to afford a luxury holiday, but not reasonable maintenance. The minor child is not his priority, or perhaps it suits him that the applicant carries the full burden. In this instance, the court found that the mom's reasons for relocating were bona fide, which we know from, I believe, the one that is being referred to quite a lot now is Jackson versus Jackson. And I'll share the, let me quickly post the citation for you. Jackson versus Jackson, SCA. And that is at 318. Generally, the court will not likely refuse leave to remove a minor child if the custodian's parents' decision to immigrate is shown to be bona fide and reasonable. In most cases, even if the non-custodial parents' rights are materially affected, the best interests of the children are served if custodian parents are not thwarted in his or her endeavor to immigrate pursuant to a decision rationally and genuinely taken. And the court favored this view in TR versus SM and granted the mom the leave to relocate. All right, folks. Removal of a liquidator, SSM versus PJNO. In this instance, the removal of the liquidator was dismissed. And the court looks at the role and the powers of the liquidator. Bundle pages 194 to 206. Short read for those of you who do winding up or divisions of joint estates, etc. Very, very key decision to look at. What happened? The dissolution of a joint estate following a divorce. Applicant sought the removal of the liquidator, alleging overreach of powers and bias. The key issues revolved around the powers and the discretion of the liquidator in handling the joint estate, including the sale of a common home and allocation of expenses. The court dismissed the application and found no merit in the allegations against the liquidator. This under the pen of Lachransi AJ in the North Gauteng High Court. Notable quotes: considering the above carefully, the court is not at all satisfied that it is desirable that the liquidator should be removed, especially in this instance where the objection against the liquidator is based upon accusations of overt biasness, where in instance where the liquidator has merely applied his discretion. The court is of the view that the attack on the liquidator and his powers is based upon wrong conclusions, ignorance of the law, and a disregard of the terms agreed upon in the settlement, followed by an attitude of obstructiveness. What I want to also draw your attention to, esteemed colleagues, is paragraph 12 to 7 or 12 to 17 of the judgment, and that deals under the heading of adjustment post decree of divorce. So now we know, in terms of section 15(9) of the Matrimonial Property Act, the court can order a redistribution, so that if there was damage suffered by the joint estate, that the one party could get an adjustment in their favor. It's long been held, folks, that section 15 is only really done at divorce. Lachranzi AJ, in his judgment, puts up an argument to say that there should actually, that it should be capable of being done after the divorce decree has been granted. This is obviously just obiter in the judgment. Nothing in the judgment turns on this, but it is interesting to see from page 12 to 17, and then if you want to go on to 19 as well, where the court sums up their contentions on an adjustment claim post-divorce. It is interesting to read. I'm not sure to what extent this will be followed by other courts, but it is interesting to see Lachranzi AJ's reasoning in doing it. Oh, thank you so much to the guys giving me comments from YouTube and sundry. I really appreciate all your feedback. I really appreciate you being here, and I'm glad to see that you are enjoying it. Right, folks, we are in the home stretch. On our case law bundle, we are on page 207 out of 244. And next up, we are going to all the way down to Bloemfontein for an urgent application in the Free State High Court under the pen of Laubscher J. And this is essentially an urgent application where there was already children's court proceedings pending. This is a cautionary tale, folks, on what I believe we call colloquially forum shopping. I don't think that any of the parties here were necessarily aiming to forum shop. However, the court took a fairly hard line on them and essentially sent them back to the children's court. What happened here? Care and residency of two young girls aged 4 and 2 following the divorce of their parents in October of last year. Now, this divorce, folks, was by consent between the parties. There was a settlement agreement signed, if my memory serves. The applicant sought to overturn children's court order where they requested primary care and suspension of their maintenance obligations. There were allegations of sexual abuse of the older child by a family member living with the respondent. The children's court had ordered an investigation by a social worker, and the report was pending. At this time, the other party, the applicant in this case, approached the High Court in Bloemfontein on an urgent basis, wanting primary residence. And essentially, the court simply said, I can't do anything. We have to get the report first. Paragraph 11 on page 210, the court says, this court is presently in no better position than the children's court to determine the real reason for A's behavior, because there is not yet a report by a social worker. And interestingly, for those of you who are following Spartan Case Law, if I may just plug them for a bit, I don't get paid by them. I just think it's a phenomenal service for those of you who want daily case law updates. On today's update, there was a judgment also where the court had to deal with a lot of issues without the benefit of a family advocate's report. And I think we must, as practitioners, be alive to how difficult we make the court's job if we approach the court, especially on affidavit, and there is no report and the court is called upon to adjudicate these matters. What could the court in SB versus CB do other than say, guys, follow the process. I can't do anything until we know what the social worker has to say. Paragraph 13, the court says, it follows that the proceedings in the children's court must be allowed to run its course. The court does not need to interfere with that process at this stage. The deed of settlement must also remain in place until the children's court has pronounced itself on the matter. The court made also quite a few findings regarding the applicant approaching the court to overturn the apple cart after they had signed a settlement agreement, essentially giving primary residence to their ex-spouse. Right. I think this might be, okay, no, I think it's our second to last one. We're going to make it home just in time for 10:30 for me to grab a cup of coffee before the next session at 11 o'clock, commercial litigation and labor law roundup. Universal partnerships, folk. This is a appeal to the full bench constituted the quorum Opperman J, Wilson J, and Norco J. Unanimous judgment from the three judges. The judgment penned by Wilson J. The judgment can be found from page 212 to 228, and this revolves around a universal partnership in the context where one of the parties to the universal partnership had passed away prior to a decision being made on the universal partnership. LL, which was the live-in partner of the deceased, sought a declaration of universal partnership with EH, the deceased, and that it had subsisted before EH's death on 21 July 2016, matter obviously coming a long way. And the claim was against EH's daughter, CH, who was the executrix of the estate, among others. The court a quo dismissed the application for declaration of universal partnership, essentially saying that they shouldn't have proceeded on affidavit. There was a factual dispute. The full bench overturned and said essentially they are, the court was well suited to make a finding on the papers, on affidavit. There wasn't really much of a factual dispute. What is interesting is obviously the restatement of the principles is Butters in Butters versus Mukora, our seminal SCA judgment on universal partnerships, and essentially paragraph 6 of the judgment, the court gives a nice overview of how do universal partnerships work, and a partnership exists if each of the parties brings something into the partnership or binds themselves to bring something into it, whether it be money or labor or skill. If the agreement is struck for the joint benefit of the parties and if the object of the partnership is material gain. We know those are questions to answer when deciding whether there is a universal partnership or not. Then, last but certainly not least, folks, TC versus BC, which snuck in right at the end of January, the judgment date 25 January 2024. Parties married in community of property in 2010, 2 minor children. Post-separation, the children stayed with their father, the respondent. The applicant living with her partner in KwaZulu-Natal sought maintenance and legal cost contributions, asserting financial dependence on the respondent during their marriage. This is from the Johannesburg High Court under the pen of Mahomet A.J., and it deals with various issues. What I found interesting about this matter is just basically at paragraph 13 on page 235 of the paginated bundle, the extent to which H versus H, which was obviously under the hand of Victor J, regarding the constitutional lens in Rule 43 matters, seems to be universally followed. Now, I'd love to hear some of your experience as the attorneys and advocates who are in the session today, but we are seeing that H versus H, and specifically paragraph 3 from that judgment, and I'll put it up on the screen, I think is really the nub of the H versus H judgment by Victor J. Let me just get it to format nicely on the screen, then I'll pop it up for you. There we go. This is a quote from H versus H, which seemed to be followed in TC versus BC. It is without a doubt clear that the dispute about the care of children, the interim maintenance, and the contribution of legal costs must be viewed through the prism of the Constitution and, of course, in relation to the Children's Act. This seems to be setting the pace. Right. Paragraph 16 of Mohammed AJ's judgment in TC versus BC. In my view, where the facts are ascertained and a mediated solution is a sensible one, particularly when parties both claim they cannot afford legal costs. Folks, I've put this one in specifically again to the mediators. Mediation presents a cost-effective and efficient procedure to dispute resolution, and in family disputes, they have the potential to preserve important relations between parties who continue to be parents to their children well after divorce. A litigant cannot plead poverty, financial pressure, and yet discount the value of this very cost-effective and efficient method of dispute resolution. Rule 41 Cap A is available to parties and must, in these difficult financial circumstances, be litigants' first port of call. Definitely a mediation friendly case. And folks, my appeal to all of you mediators in here, please stop quoting Brassy AJ in MB versus NB. It was a phenomenal case, but it is almost old enough to start buying its own liquor. It is now 16 years old. There is a lot of very good mediation friendly, up to date judgments to rely on. MB versus NB, obviously the reported judgment from Brassy AJ, where the parties' attorneys were wrapped along the knuckles for not considering mediation. Fantastic judgment, though it may be, but I do appeal to you. There are at least 4 judgments in today's session which are very mediation friendly. Go and have a look at those. I have made a point of putting these quotes into the summary table as well. For those of you who have not yet picked up the summary tables, please feel free to do so. You can find them on our Shopify page. It is obviously also a great way to assist Nadia and myself in what we are doing in trying to make legal knowledge and up-to-date legal information available. Someone says, Eugene says mediation-friendly cases are brilliant, and I agree with you. Folks, we saw yesterday a lot of robust discussion on various other platforms. I must be honest, when Nadia and I had our evening whiskey, I was feeling very, very drained and very tired because it was very robust discussions. And we, at a few spaces yesterday, we thought, sure, but are we going to intervene on the WhatsApp groups or not? And we decided to not intervene because these are all discussions that need to take place. But there is good news, guys. The courts are starting to see the benefits of mediation in these cases. And I think that the tide is turning. How long it's going to be until there is full-on law reform regarding mediation is uncertain. I know the guys at Law Reform are working very hard on it. For now, it's good to see that the culture is changing within the courts, and we as practitioners also have the power to change the tide and work in a more collegial, more conciliatory way for the benefit of ourselves, our colleagues, and most importantly, the families we seek to serve. So that concludes our slew of cases for January of 2024, 17 cases. I will be putting up the event for the February roundup a little bit later today, or a little bit earlier next week, or sometime next week. I sat this morning starting with my summaries for the February one, and there are already 5 cases, and it's only the 2nd of February. So this is going to be a short month with lots of judgments. So please do join me for next month's session, which will once again be a free session. We will be making available again our summaries and our slides for those who would like them. It is obviously optional. You are free to attend free of charge. Guys, join us on WhatsApp. Come see the robust discussions happening at the moment, and keep your ear to the ground in what is happening in the industry on the Think Legal Family Law WhatsApp group, as well as the Commercial Litigation and Labor Law WhatsApp groups. Finally, just a reminder, Divorce 101. Those of you who would like to join us, we have that promo code 20% off today if you use recap 2023. I have reactivated, and VLaw 10. It is also a great way to support what Nadia and I are doing here. Guys, last thing before we wrap up, with 5 minutes to share. And I say this also in terms of our on our summary page. And I'll read it out to you, folks. The provided case law summaries are intended solely for general information purposes and to fast track you into reading the judgments yourself. Don't underestimate the benefit of reading the judgments and critically evaluating them yourself. The summaries do not and cannot encompass all aspects and nuances of the judgments and should not be relied upon as a comprehensive source of information. And for Pete's sake, don't draft your heads using ChatGPT. But a starting point in critical analysis, these certainly are. They are there to help you. For thorough understanding, readers are encouraged to consult the full text of the cases. Folks, I have been Mervyn Vermeulen, and I would like to thank you sincerely for taking the time to sit with me. Today we had over 100 people in this session, and we stayed over 100 people, and that was phenomenal. And I thank you for taking the time out of your busy practices to spend this time listening to us and to expanding your knowledge base and the knowledge base of the community. This recording will be live. You can watch it immediately afterwards if you want to catch up on it. For those of you who are into podcasts, we will have it up on the Think Legal podcast within the next day or two. And from my side, as we close off the stream, thank you so much for watching. Thank you so much for being a part of the Think Legal community and for supporting us in what we do and upskilling yourself to better serve your clients. I wish everyone a phenomenal weekend. I'll be back here in 35 minutes for the labor litigation and commercial law roundup, where we will also be looking at some very interesting judgments for you. For those of you joining us there, I look forward to seeing you. For the rest of you, have a phenomenal weekend, and I will see you all in WhatsApp land. Have a great weekend, everyone, and thanks again for attending. Goodbye.